oral fluid drug testing, what employers need to know. So that's the topic, and hopefully you're in the right place. We welcome you. We thank you for joining us. This is U.S. Drug Test Centers providing the information on DOT oral fluid drug testing. My name is Joe Riley. I'm your presenter today. I'm a consultant for U.S. Drug Test Centers and a trainer. Been in the business of drug and alcohol testing just about 30 years as of this year, and very actively involved in training and consulting DOT regulations, and excited to be here today with you to be presenting on this topic, DOT oral fluid drug testing, what employers need to know. So we're going to give an overview, and we have plenty of time for questions. We scheduled this training for 75 minutes so that we do have plenty of time for questions. And we also have 2 handouts that are available to you to download in the GoToWebinar control panel. So if you can at some point in time go to the GoToWebinar control panel and download those 2 handouts. There's also a questions box where you can type in any questions you have, and we'll answer those questions as we go. And we'll have time at the end for additional questions. We'll also provide at the end email contact information for you to email any additional questions. Later on today, by the end of the day, you'll receive a follow-up email from the GoToWebinar system. It will include a certificate of attendance that you attended this webinar, and it will include the recording of the webinar. So if you want to go back and listen and view the webinar again, or share it with someone in your organization, you will have the ability to do that. So again, we got a questions box. You can pop in questions as we go. And we have 2 handouts that you can download. One of the handouts is just a 1-page important information regarding DOT oral fluid drug testing. The other handout is a copy of the PowerPoint slides that we're presenting from. So we know that someone always asks for those copy of the slides. So we are providing that in the handout. If for some reason you can't find where you can download those on the GoToWebinar control panel, you'll have an email at the end that you can send an email and request those handouts. So let's get into it. DOT publishes a rule on May 2nd, 2023, a rule that, among other items, authorizes employers to use oral fluid drug testing as an alternative testing methodology to urine drug testing. So this does not replace urine drug testing. It adds an alternative testing methodology, specifically oral fluid. Now, the United States Department of Health and Human Services, or HHS, passed oral fluid drug testing in its mandatory guidelines about 3 years ago, and those HHS mandatory guidelines affect employees of the federal government. So that's been authorized for 3 years. DOT has a mandate to harmonize with those HHS mandatory guidelines, but it took them a little bit longer to incorporate oral fluid testing into the DOT regulation 49 CFR Part 40. DOT went out with a proposed rule and a comment period. They received close to 500 comments from the industry, from employers, from interested parties. They read all those comments, they addressed all those comments, then they came up with the final rule that was published May 2nd, 2023. So this rule harmonizes with the pertinent section of the HHS mandatory guidelines on oral fluid drug testing. It also clarifies certain Part 40 provisions that cover urine drug testing. So there's some additions, clarifications, replacements in Part 40. It removes some provisions that are no longer necessary or perhaps obsolete. It adds 8 new definitions, clarifying language to some definitions, providing some new web links, and it updates some provisions of Part 40 to address issues that have risen in recent years. We're going to touch base on all of this stuff as we go through today's presentation. And all of this applies to all DOT agencies for drug and alcohol testing under 49 CFR Part 40, which is the overall DOT regulation for drug and alcohol testing. So the DOT agencies are the Federal Motor Carrier Safety Administration, or FMCSA, the Federal Aviation Administration, or FAA, Pipeline Hazardous Materials Safety Administration, or PHMSA, Federal Transit Administration, or FTA, Federal Railroad Administration, or FRA, and also United States Coast Guard, USCG, regulated by actually the Department of Homeland Security, but they follow DOT drug and alcohol testing rules. So we have a published rule, and the effective date was June 1st, 2023, the effective date of the published rule. However, DOT oral fluid drug testing is not yet operational. Why? Because laboratories doing DOT drug testing must be certified by the Department of Health and Human Services, HHS, specifically SAMHSA, the Substance Abuse Mental Health Services Administration. So the labs need to apply for the certification to do oral fluid drug testing. Now, the same labs have been certified for many years to do urine drug testing, but it would have been difficult for them to apply for certification for DOT oral fluid drug testing before the DOT even allowed oral fluid drug testing. And we're actually going to need 2 laboratories to be certified by HHS, both using the same collection device before DOT oral fluid testing can become operational. So we need 1 lab for the initial testing and another lab that can do the split specimen retest request when there is a split specimen retest request. And therefore, that would require both labs to be using the same collection device. Now, talking about a collection device for oral fluid drug testing, it's a little bit different than the collection device for a urine drug test. The urine drug test is just a plastic cup, very inexpensive, and 2 vials that the urine goes into, and they get sent to the lab, an A bottle and a B bottle. With oral fluid, we're using a specific collection device that has reagents for the oral fluid to stick to the device, and it has to be a device that can be split into 2. I call these devices a sponge on a stick. It goes into the mouth to collect oral fluid. So we have 2 sponges on a stick that can be broken off once the oral fluid is collected, and 2 sponges go into 2 separate bottles, the A bottle and the B bottle, and they both go off to the lab. Just like with urine testing, nothing happens to the B bottle, and if the test is negative, the B bottle is discarded. But if the test is non-negative, the B bottle is stored at the laboratory in case there is a request or a challenge to the original testing, so that that second specimen can be retrieved and sent to another lab for the retest. So we need 2 labs certified. by the Department of Health and Human Services, specifically SAMHSA, both using the same collection device. Now, there's about 20 labs, 20 plus labs currently certified for urine drug testing. Probably not all of them will apply to be certified for oral fluid, but the major ones will for sure apply. And you may be familiar with Quest Diagnostics and LabCorp, two of the largest laboratory organizations in the United States, both of whom have multiple labs in their system, 3 or 4 labs. And these labs are certified separately and independently. So, for example, Quest could have 2 of their labs certified, and that would enable us to have DOT oral fluid drug testing become operational. Or LabCorp could have 2 of their labs certified. Now, an important distinction when we talk about a lab or a laboratory, we're not talking about the Quest or LabCorp facility that your employee drives to give his or her specimen. Those are what we call patient service centers or collection sites. Those are not the actual laboratories. Quest and LabCorp have 3 or 4 laboratories each throughout the United States, not hundreds and hundreds in every community. The hundreds and hundreds in every community are the collection facilities, what we call the patient service centers or the PSCs. So the new DOT rules for oral fluid testing, drug testing, have been updated in 49 CFR Part 40, which is available currently in the Federal Register, and very soon it'll be available as a separate PDF document similar to the prior 49 CFR Part 40, but you will want to use the new 49 CFR Part 40 effective June 1st, 2023. And for oral fluid testing, applicants and employees could be subject to either a DOT oral fluid collection or a DOT urine collection for any DOT regulated test. So for some employees, you might say we're going to do oral fluid. For some, you might say we're going to do urine. For some different test types, you might say we're going to do oral fluid for post-accident and reasonable suspicion, but we're going to do urine for pre-employment and random. And like it is today, sometimes there's a reason during a testing event for a second collection. That's typically after we have a temperature out of range or we have an insufficient quantity of urine. So we have a need to finish the first collection and start a second collection. And with this new rule, the employer will have an option to choose to change to the other type of collection to finish the collection event. So for example, we started with urine, we got a temperature out of range, we're now going to do a oral fluid collection. The choice of whether to start with oral fluid or start with urine or change to oral fluid or change to urine, that choice is going to be up to the employer. It's not an employee decision. It's not an MRO decision. It's not a collection site decision. It is up to the employer. And we're going to talk a little bit later about how an employer will communicate their choice to the collection site where the collection is being done. So when should oral fluid testing be utilized? Again, it's going to be up to the employer with one exception. And this is the only exception where there's a hard rule, okay? When a direct observed collection is required, for whatever reason, a direct observed collection is required, and the donor involved identifies as non-binary or transgender, it will be required that the direct observation collection be with oral fluid. So this will eliminate the uncomfortable situation of a direct observed collection that has to be the same gender, and we don't know what the gender is, or we're confused about the gender. So it's going to be up to the donor, the employee or applicant, when there's a need for direct observed only, and they say they identify as non-binary or transgender, that the event will become an oral fluid collection. There's some other compelling reasons where an employer may say, we want to do oral fluid. One is because there's a shorter detection window. We're picking up recent drug use, going back perhaps even a few hours, might be more appropriate for reasonable suspicion or post-accident testing. For any direct observation, so anytime there's a direct observation, it might be more appropriate to use oral fluid because that would eliminate the uncomfortable process of someone going into the bathroom with the employee, someone of the same gender, and the possibility that your employee goes for the test and there's no one of the opposite gender available to do the direct observation. For example, a male donor goes into a collection site and the direct observation becomes required, and there are only females working at the time at that collection site. The employer can say, let's do oral fluid. With a urine collection, someone has difficulty providing a sufficient amount of urine, 45 milliliters as a minimum. Today, or prior to this rule, or prior to when we start doing oral fluid drug testing, they go into what we call a shy bladder process, where they're given some water, they can relax, and they can try again. They can try again in 15 minutes, they can try again in a half hour, whatever it may be. And they have up to 3 hours. They have up to 3 hours to provide that sufficient urine specimen. So why not switch over to oral fluid to avoid the 3-hour wait time? That's going to make a lot of sense. It can save money. It could be more efficient, not burning up hourly wages. You can get your person back to work. The big question we get is, when is oral fluid testing required? Well, it's not required, again, with the one exception. And you're going to hear me repeat a few things during this presentation. And those things that I repeat are really important. That's why I repeat them, okay? So oral fluid testing is not required, with one exception. When a direct observation collection is required, it's required for whatever reason per the DOT that this collection must be directly observed. And the donor is identifying as non-binary or transgender, that direct observed collection must be with oral fluid. Otherwise, DOT oral fluid direct testing is an alternative for an employer to use at the employer discretion. Urine specimen collection is still an option. The applicant, the employee, the collector cannot make the choice to use urine, oral fluid, or a combination of both. This is an employer decision. So who decides whether to use oral fluid? The employer has the decision-making authority. They can start with urine, they can start with oral fluid. If a second collection is needed, they can switch from one to the other. They can use oral fluid in certain situations, certain reasons for testing. They can use urine in certain situations certain reasons for testing. These are all up to the employer. So, for example, you have an employee who has a history of trying to cheat on the drug test, and you know that for some reason, but you know it. And it's easy to cheat on a urine drug test. If you know it's coming, you can study for it and cheat on it. So at the last minute, you say, we're going to do oral fluid. We're not going to do urine. So if they got a bottle of yellow liquid strapped onto their leg, it doesn't help them anymore if you're switching over to an oral fluid collection. Don't forget, we do have the questions box. Please pop in any questions you might have. We have a lot of people on the webinar, so I'm sure some of you are coming up with questions. It is important. It helps everybody if there's questions, because you may have thought of a question that somebody else didn't think of. You might even think of or come up with a question that I didn't think of. So please pop any questions into the questions box. So the next question that we ask is, who can collect specimens for oral fluid drug testing? Well, only those folks who are trained, qualified, and have completed what we call proficiency demonstration or mock collections. So there will be a training program, and then mock collections must be done. That's where you do 5 practice collections, error-free, in front of someone who's qualified to monitor those 5 mock collections. And if multiple collection devices become approved, and you're going to use more than one collection device, you're using perhaps more than one lab as a collection facility, you have to be trained and have proficiency demonstration on each specific oral fluid device being used. And those folks that are currently certified or qualified for urine specimen collectors, that does not automatically make them qualified or certified for urine specimen collections. So the 20,000 folks that are currently out there that are qualified and have already done proficiency demonstration for urine will also need to do the oral fluid testing training and qualification, and will need to complete the proficiency demonstration or the 5 mock collections. So a couple of questions. Can it be on non-DOT? So great question. Oral fluid drug testing for non-DOT has actually been around for over 10 years. So for over 10 years, you could have been doing non-DOT oral fluid collections. And you can certainly start that tomorrow. So you would want to get with your drug testing provider, your consortium / third-party administrator, U.S. drug test centers, and talk about getting accounts set up for non-DOT oral fluid drug testing. And once we have 2 labs certified and a collection device approved for DOT, you'll work with your C/TPA to get accounts set up for oral fluid DOT testing. So just because you're doing urine today, it's not automatic that you'll be doing oral fluid. You have to set up an account for that. 2 separate accounts, 2 separate account numbers. Some labs have indicated you could write the oral fluid account number on the DOT form that you're currently using for urine. The form is already set up for oral fluid collections, and some labs have indicated there'll be 2 separate forms, one for urine, one for oral fluid. Just a note on the collection device being used. Those collection devices will have expiration dates, and the collector will be responsible to review that the device is not expired, to indicate on the paperwork that the device is not expired, and actually to record on the paperwork, the custody and control form or CCF, to record the actual date of expiration. Now the question is dry mouth handled the same as shy bladder? Great question. Somewhat similar, but it won't be a 3-hour period. It will only be a 1-hour period. So and these collection devices will have an indicator to indicate you've collected enough oral fluid. So I believe it's after 10 minutes, it might be 15, you're not getting enough oral fluid. So you would stop that collection, let the person drink some water. They can try again, and they have up to 1 hour. After 1 hour, that dry mouth event will be over, and the individual can request from the employer to be evaluated by a physician for a dry mouth, to have a physician say yay or nay, this person has a medical condition that prevents them from producing an appropriate amount of oral fluid. That's going to be rare, but it is just like with the shy bladder. After 3 hours, an employee or an applicant can be evaluated by a physician to see if there's a medical reason why they can't urinate in 3 hours. There'll be an opportunity for an individual who can't provide oral fluid within 1 hour to see if they have a medical explanation. In either case, instead of waiting the full hour, you could do a urine collection. If it started with urine, instead of waiting the 3 hours, you could do an oral fluid collection. Another question, what's the difference, the cost difference between the urine and oral testing? So there's a couple of variations there. With the oral fluid testing, the collection devices are not really cheap, like with a urine cup. Urine cup is like 5 cents. Okay. The collection devices cost several dollars, if not $3 to $4. Okay. So the labs are going to tack that on to the cost of testing. So if you're paying someone to do the specimen collection and they have to use a collection device and they have to have lab testing done, that cost is going to be the cost of all that put together. It's going to be a little bit more than the same cost of a urine collection, urine lab work, MRO, etc. If you're an employer and you're doing your own oral fluid collections, well, then you're going to save the cost of an outside party doing the collection. So in that case, it would be less expensive, but you are using your own folks, and your own folks will have to be trained and qualified, and you'll have to buy those collection devices. Still overall less expensive than sending somebody out to a collection site. Another question, are there circumstances when you cannot use oral fluids? So no, you can use oral fluid for any DOT collection right from the start, or you can switch over to oral fluid if a second collection will be required. Next question. Hello, I am the DOT FMCSA Safety Director for a staffing company. I have approximately 20 managers who sends for applicants for pre-employment testing every day. And let's see if I can find the rest of the question there. Hopefully it's on the next line. I have more. I hit the button too soon. Just go ahead and continue the question in the next question. You don't need to repeat it. So let me go to the next slide and I'll answer that question. Can employers perform in-house oral fluid specimen collections? Yes, they can. But the folks that are doing those collections need to be trained and qualified. Just like with DOT urine collections, you could have always done those collections yourself, as long as the collector was trained and qualified. Now, collecting urine is, it's tedious, and we've got the yuck factor of urine, so not everybody wants to do that. But oral fluid collections still need the training, still need to do the proficiency demonstration mock collections. So once you're qualified, you can do them. So your organization can train someone to do them. Is there training or certification for my managers to administer? So yes, there is. Okay. The training is not yet available. It won't be available until such time as we have 2 certified labs and an approved collection device, because we have to train you on that approved collection device. So we'll cover that a little bit more on the next slide. Okay, again, collectors must obtain training to show proficiency in the operation of the particular oral fluid collection device to be used. And if you use more than one lab, and those labs use different collection devices, you would need to be trained on each device. Now, if you're an employer and you're using one lab, let's say Quest or CRL or LabCorp, they use one device, that lab, you only need to get trained on that one device. Training is not yet available. Training will become available once we have everything in place. The training requirements are outlined in 49 CFR Part 40, Section 40.35. Now, 40.35 used to say something different. Some of the sections in Part 40 have been renumbered to account for the new information. But if you wanted to look right now at what those training requirements are, you could go to 49 CFR Part 40 and go to Section 40.35, and you could review the training requirements for someone that's going to get trained to do oral fluid drug test collections for DOT testing. So we've talked about these mock collections. So the person being trained needs to do these 5 practice collections real time in front of someone who can be the person that monitors these real-time mock collections. Well, one, it could be someone who has regularly conducted oral fluid DOT drug test collections for a period of at least 1 year. Well, currently that's no one, because no one has conducted DOT oral fluid drug test collections. Or it could be one who has conducted DOT oral fluid collector training for at least 1 year. So currently that's no one, because no one's been trained or been a trainer for DOT oral fluid collector training. So the only option would be the third bullet point there, is someone who has successfully completed a train the trainer course. So if you're going to be getting someone to train your folks and monitor those mock collections, I would highly recommend that you ask for a copy of their certification of completing a train the trainer course specifically for oral fluid drug test collections. There'll be folks that meet that requirement. At first, it will be, a few dozen, and a few more dozen, and over time it will be more people. And a year or so into it, there'll be even more people available that can monitor these mock collections. So U.S. drug test centers will notify clients and others as part of their marketing efforts and their client customer support communications when the training becomes available. The requirements to attend the trainer course will be initially just to attend it, okay? Because there's no prerequisite because there hasn't been any DOT drug test collections. As time goes on, there may become a requirement where you have to have been trained as a collector first, but initially it will all be done at one time in a train-the-trainer program. So what are the benefits of oral fluid drug testing? Why are we doing this? I got this question the last time we did this webinar presentation. Well, why do we have oral fluid testing? Well, because it's an easy collection, it's an alternative, it's always direct observed, and there's no gender requirements. There's going to be less cheating on oral fluid testing than there is on urine testing. It's a non-invasive specimen collection. We're not dealing with pee. We're not dealing with collecting pee. We're not dealing with the yuck factor. It's a method that causes minimal health and safety concerns. As we've discussed in the last couple of slides, employer representatives, employees of your company, can be trained to collect specimens on site at employer premises. Now, will every employer elect to do that? No, but some employers might. Some employers might say, we're going to have our safety manager trained to do oral fluid collections. Are they going to do all the drug testing for the company? Maybe, maybe not. Maybe they're only going to do post-accident and reasonable suspicion. Maybe they're still going to send folks out for pre-employment, random, etc. Oral fluid drug testing has a shorter window of detection, which makes it easier to find recent drug use. Recent drug use is what we're trying to find out on a post-accident drug test and on a reasonable suspicion drug test. So it might be advantageous to say, we're going to do oral fluid on all post-accident and reasonable suspicion drug testing. Oral fluid testing can eliminate the shy bladder 3-hour wait time and can eliminate the direct observed urine collection, the uncomfortable nature of the direct observed urine collection, the requirement of someone of the same gender for the direct observed urine collection. So it might be appropriate for a company to say, we're going to do anytime a direct observation is required, we're going to say use oral fluid. So some of this repeats, but some scenarios where oral fluid drug testing might be more beneficial than urine. Well, maybe you're in a remote area and the nearest place to find a urine collection is 3-4 hours away. And in the past, you struggled with that because you didn't want to do urine collections. You could have, but you didn't want to. But now it might be easier to do in-house collections with oral fluid. After hours testing, when facilities are closed and you have a need for a post-accident test or a reasonable suspicion test, it just might be easier to have your own employee do the collection. Or it might be easier to find someone to come out and do that oral fluid collection. Again, anytime direct observation is required, and again, anytime someone goes into a shy bladder, and you can potentially eliminate the 3-hour wait time. Now, how does an employer communicate all of this to the collection facility that's doing the collection? So if you're doing it in-house, your own employee, well, they're gonna know what your policies are and what you want done. But how does the local clinic know that? The place where you send people, okay? And what DOT has said in the final rule, what they call the preamble, where they kind of talk about how they got to the actual rule, they are recommending what they're calling standing orders. So standing orders would be a written order from the employer that says, we want to use oral fluid testing all the time. We want to use urine drug testing all the time. or we want to use oral fluid anytime direct observed is required. And we want to use oral fluid anytime a donor goes into a shy bladder process. Or we want to use oral fluid anytime the initial urine specimen shows temperature out of range or it appears to have been adulterated or substituted. Or we want to use oral fluid specimen collection anytime we're in a remote area, we're finding a collection site is difficult, and we're going to train some of our own people to collect oral fluid. And we want to use oral fluid on every post-accident test and on every reasonable suspicion test, and maybe on every return to duty test, because those are all required to be done under direct observation, and also on all follow-up tests, because those are all required to be under direct observation. So you'll either communicate these standing orders directly to, if you use the same clinic all the time, it's pretty simple. If you use multiple clinics in multiple states around the country, you'll want to communicate it to your TPA, like U.S. drug test centers, and they can communicate on your behalf to the collection sites. But you're going to want to have these standing orders, because otherwise that collector has to find you any time during the day or night when they're doing a collection and they don't know whether to do oral fluid or urine. And we're going to talk about that a little bit more in just a minute. The question is this a 5-panel drug screen, or can we also do alcohol? So for DOT, this is the DOT 5-panel drug test. Alcohol rules have not changed. You would not use this oral fluid device for an alcohol test. You would use a breathalyzer, or you might use an instant saliva alcohol screening test that's approved by DOT. This particular device will be approved for drug testing only, and it will be the same 5-panel. Now, if you're doing non-DOT oral fluid testing, you could do a 5-panel, you could do a 9-panel, you could do a 10-panel, and you can also add alcohol to it. But that's not the case for DOT. Pre-employment tests can be in-house oral fluid. Any test can be in-house oral fluid. Any test can be in-house urine. But if you don't want to train someone and have them keep up with their training and get them qualified, you don't want to deal with it, you're going to use a clinic like you have, and clinics and Quest Diagnostics and LabCorp facilities will all be available to do either urine or oral fluid. So the question is, what if there's no standing order? Okay, so if there's no standing order, the collector must contact the designated employer representative, the DER, and either conduct an oral fluid test if the DER states that that's what they want done, and the collection site is able to do so. Because remember, the collection site has to have trained personnel to do oral fluid testing, or they would have to send the employee to a collection site acceptable to the employer for the oral fluid test. So this kind of relates to what we've had in the past, is someone goes into a clinic for a urine collection, and let's say, for example, their specimen comes back temperature out of range, and so now they need to provide a second specimen, and in the past and currently, that's urine, okay? And it has to be direct observed by the same gender, and it's a male, and there's only female employees working in that clinic. So now there's an issue, now there's a challenge. So what were they supposed to do at that point in time? They were supposed to call you, the employer, and ask you to either send somebody down to do the observation or have you find another collection site to have that person go to for that direct observed collection. So moving forward, you have to be available to collectors. And we're going to see in just a few minutes, DOT in their revised 49 CFR Part 40, in their tweaks and clarifications, they are stating, although this has been the case all along, that a DER must be available 24/7. And there must be a phone number available to a collection site to reach the DER 24/7. Because if somebody's in there at 8 o'clock at night and there's a question, the DER has to answer the question. If somebody's in there at 8 o'clock at night and there's a positive alcohol test, the DER needs to be notified immediately of a positive alcohol test. So now, as an employer, you can have one DER, you could have multiple DERs, but there must be a phone number where a DER can be found 24/7. And the DOT is going to be looking for this, and folks could end up with penalties and fines if it's not available. Now, laboratories. So laboratories, we've talked about, are going to need to be certified by Health and Human Services, by FMCSA. It's a rigorous application process. It requires insurance requirements. It requires testing and trials. And then it requires rigorous quality control and inspections. And the lab will identify the collection device that they're using, and they'll show during testing and trials that that device works. Again, I mentioned those devices will have an expiration date, okay? The collector will be required to indicate on the custody and control form that the device is not expired, and they'll also be required to indicate on the custody and control form the date that it does expire. Now, when the lab gets the specimen, which is the collection device, is the specimen, if the collector has not indicated it's within expiration and also indicated the expiration date, the lab will need to check for the expiration date. The collection device is expired, the lab will reject the specimen for testing, and that will be a fatal flaw. If the collector failed to record the expiration date, but the lab verifies that the device is still within prior to the expiration date, the lab will note the correct date and proceed with the testing process. So it's going to be a collector responsibility, but the lab is going to be there to pick up the slack if the collector doesn't insert the date on the form. The laboratory will check the device to see if it is within prior to the expiration date. The labs also have a requirement to provide biannually some data to the DOT regarding all of the oral fluid drug testing that they are performing. So a couple of more questions. For DOT, I can already be completing an alcohol screen in-house with the oral test if I was trained. Sorry for all the questions. So not quite, okay. So if you're currently doing alcohol testing with a breathalyzer or an initial saliva screen, you can continue to do that. Nothing changes. The oral fluid drug test device will not be used for any alcohol testing. You will need to be trained and qualified on the new oral fluid drug testing devices that come out. They will not be used for any alcohol testing. Next question. If I have a standing order with U.S. drug test centers, will they communicate that on the COC to the collection site? We use many different collection sites throughout the country. So that probably means you're electronically scheduling tests. Maybe you're sending out 5-part paper forms. It is anticipated that the laboratories, Quest, LabCorp, Alere, that the laboratory systems, which you have an account with through U.S. drug test centers, the laboratory systems will note in your account number your standing orders, so that when a collector pulls up your scheduled test to perform that test, they'll see the standing orders. That's what is anticipated. Another possibility is that U.S. drug test centers will notify every collection site of your standing orders, and also be available to take a phone call to relay your standing orders. So one way or the other, between you developing your standing orders and working with a professional TPA like U.S. drug test centers, your standing orders will get communicated. Okay, so we got somewhat of a revised version of 49 CFR Part 40. What did they say about the medical review officer? Well, they say that the medical review officer does not have to undergo any initial recertification training. So MROs are certified for 5 years. They don't need to automatically go get their 5-year recertification. If they're 2 years in, they're still fine. They're 3 years in, they're still fine. MROs are also, though, required to have annual continuing education. Oral fluid drug testing will be discussed in their annual continuing education. When they renew their main certification every 5 years, oral fluid drug testing will be covered. As a matter of fact, I attended about 3 months ago, before this was even published, an MRO recertification training, and they're already covering oral fluid drug testing. So MROs are fine. A little minor change is, in the past, when a donor claims a medical explanation like a prescription as a reason for a positive drug test, the MRO, the licensed physician, had to verify that with the pharmacy. They don't just take the employee's word for it. Okay, I have a prescription for Adderall. That's why I'm positive for amphetamine. Okay, what's the pharmacy's name and what's your prescription number? I'm going to call them and verify that. If it verifies, you'll be negative. If it doesn't verify, you'll still be positive. There's a change where the MRO staff, the assistants that work underneath the licensed physician, can contact the pharmacy on behalf of the MRO. So this is a change. The third bullet point is really not new, but it's been clarified. There are times when an MRO cancels a test because they did not get a copy of the custody and control form, which they are required to review to close out a test. So if they don't get that copy, typically after 30 days, they cancel that test. So it's been clarified that they can uncancel the test if later on they do receive the proper paperwork, the proper custody and control form. So you could have a canceled test after 30 days, and then 2 weeks later, all of a sudden, you get a negative or you get a positive because the MRO finally got their paperwork. And the fourth bullet point, in a rare circumstance where an employee is not able to provide a sufficient oral fluid specimen after an insufficient urine, or vice versa, and so on the second go around, the employee can't provide enough specimen, either oral fluid or urine, the employee would only be required, if they want a physician evaluation, it would only be required for the second specimen type attempted. So for example, we started with urine, we went to oral fluid, we have a dry mouth on the oral fluid, the evaluation is based on oral fluid. And vice versa, we started with oral fluid, we went to urine, shy bladder, the evaluation would be based on the shy bladder. Okay, keep those questions coming in. The SAP, substance abuse professional. When COVID started, there was a temporary ruling where they could do remote Zoom type evaluations. This has become permanent. So SAPs can do remote, real-time evaluations through whatever technology that provides for real-time two-way audio and visual interaction, a Zoom meeting, a GoToMeeting, whatever it might be. The quality of the technology must be sufficient to gather all visual and audible information that the SAP would normally observe in a face-to-face interaction, and the technology must incorporate sufficiently robust security to protect the confidentiality of the conversation. With a caveat, the SAP, the substance abuse professional, has a license to perform those evaluations. If that license has some type of geographical limitation, like it can only perform in Texas, well, then they wouldn't be able to do the remote evaluations outside of Texas, the donors located in Oklahoma or New York or Florida or Nevada. Or the SAP may have some, the organization that provides them their credentials, their certifications, might be limited to a particular state. That may or may not be the case for any particular SAP, but the SAP must abide by geographical limitations. Some employer notes with the new Part 40 refusal determinations, that refusals that occur at the collection site are determined by the employer. It's always been this way, but there's been some mistakes. DOT is clarifying this. A collector does not make an official determination of a refusal to test. An employer should gather the documentation from the collector, investigate, and make an official determination. This is affecting somebody's livelihood. Don't take it lightly. Investigate and look at all the facts. MROs report refusals when a specimen comes back from the lab as adulterated or substituted. MROs are not making any official determination on refusals that occur at the collection site. You may see the result reported in an MRO system, which is merely record keeping so that everything's in the same system. Some other clarifications. I mentioned this before. DERs, designated employer representatives, have always been required to be available to collectors 24/7. DOT is re-emphasizing this with a big push. The phone number on the CCF should be the DER's correct phone number to be reached in case there's questions or problems. The DER should always be available to discuss standing orders on what type of test the employer wants administered if a problem scenario arises. Now, if you have standing orders, this should eliminate these phone calls. If you have the standing order with your TPA, most collection sites are going to call the TPA first anyway. Some other Part 40 additional clarifications. For many years on the CCF form for drug testing, we've recorded a social security number or an employer issued ID number as the identifying number used for an applicant or an employee in the drug and alcohol testing program on the appropriate custody and control form or breath alcohol testing form. Over the past couple of years for FMCSA regulated drivers, because of the clearinghouse, you should have been using not the social security number, not the employer issued ID number, but the state of issue abbreviated followed by the CDL license number with no spaces, no dashes, and no special characters. So for example, FL, Florida, FL, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. The DOT is saying now for all of the DOT agencies, FAA, FTA, FRA, PHMSA, U.S. Coast Guard, employers can use any state or federally issued identification number to fulfill the Part 40 requirement for a unique identification number. So you can use the state abbreviated and the CDL number, or you could use any other state or federally issued ID number. Now, as always, and I know this hasn't always happened, but as always, you should have always been using the full number, not the last 4 digits or the last 6 digits. The identification number is a unique number, unique to that person. It needs to be the full number. Computer systems cannot distinguish the last 4 digits of my number, 1111, from the last 4 digits of your number, 1111, and you might get my result and I might get yours. That's not a good thing. Now, besides the DER providing the correct phone number, DOT is emphasizing that the service agents, the collector in particular, provide a phone number where the collector can be reached or the collector's supervisor can be reached, and not using a call center number or a corporate office number. There's a change to 40.33, which deals with a fatal flaw where a collector is subject to error correction training. There's been times over the past 20 years when specimens have leaked in transit, the blame was always put on the collector. So the DOT is now saying that the collector is not subject to the time and cost of retraining for errors that occur outside the collection process. They shipped it, it was intact, and the lab got it because it bounced around in the FedEx truck and leaked. The collector is not responsible for transportation process events. Lastly, ODAPSI, which is the DOT's Office of Drug and Alcohol Policy and Compliance, the agency within DOT that oversees the drug and alcohol testing program, will produce an oral fluid specimen collection guidelines document. We hope to see that in the very near future. We currently have and have had for many years a urine specimen collection guidelines document. This will be in addition to the DOT regulation and the outline in the regulation of what's required for training. This will be in a little bit more detail and more plain English. This will be incorporated into a training manual that we will produce. And for those folks that are looking to get training from us, they'll get that manual with this specimen collection guidelines document. Once again, the training is not yet available yet. We don't have a specimen collection guidelines, and we don't have a device to train on. So that brings us to kind of the end with questions and answers. So please, we've got about 10 minutes left on our clock. Happy to answer any and all additional questions. I've got one here I'll get to, but just remind you that there's 2 handouts to download. Please go ahead and download those. And my next question, if a positive comes up for marijuana, will the MRO verify a medical card as a prescription? The answer is no. Okay, and let's go back to DOT regulations. They do not recognize medical marijuana or recreational marijuana. They don't recognize any marijuana. So in a DOT drug test, a marijuana positive is a marijuana positive. Now for non-DOT, there's a little bit of a difference, and every state's different based on the state laws, but having a medical marijuana card is not having a prescription. There's no such thing as currently today, as we speak, there's no such thing as a prescription for marijuana. You get an authorization from the state you live in to go buy medical marijuana. It's still going to be a positive test. The MRO will note on the report in the comments section, donor claimed to have a medical marijuana card. It is now then up to the employer to say, well, what's our policy? Do we accept the medical marijuana card? Do we want to look at it? Do we want to verify there is one? Do we not accept medical marijuana? Are we dropping marijuana from our testing program? You got to look at the state laws in your state for marijuana, and leadership in your company has to make decisions about marijuana in the workplace for non-DOT. For DOT, it's a no-brainer. It's prohibited. Next question, what if it got lost in transit? It's a canceled test. You're going to have to send them back for another test. Where can I find training materials or classes? Will US Drug Test Centers be offering this? Yes, you can't find training materials or classes right now because they're not yet available, but if you're on this webinar, we've got your email and you will be notified. Please continue to put any questions in. Last slide is contact information for Callie at US Drug Test Centers. Callie's a director of client services. The phone number 866-566-0261. Callie's email, Callie, C-A-L-E-E at usdrugtestcenters.com. Callie, do you want to add anything or mention anything to the audience?
Yeah, Joe, thank you so much. I appreciate everyone joining the webinar today. If you joined the last session, it's probably a little bit of a refresher, but hopefully the information was very helpful. We will continue to update everyone as we receive more information and updates from the DOT. As Joe mentioned, we will also update everyone once we receive the training information. And yeah, we appreciate you joining us, Joe. Great presentation, lots of good information. Please feel free to reach out to me with any additional questions that come up after the webinar.
Okay, great. Thank you, Callie. And I'll just give it another minute or so for any last minute questions. You can also add comments or complaints or praises. We take everything. If you liked the class, if you didn't like it, if you didn't learn something, if you thought you were going to learn something that you didn't learn, ask the question about it, and we're happy to answer it. Just a broad statement. This is a big change in DOT drug and alcohol testing, and how to get ready for it. You already started getting ready for it by attending this webinar. Look out for more information that comes from US Drug Test Centers. You'll get more information, and just start thinking about what those standing orders might be. You will get a copy of the slides is in the downloadable handouts that you should see and able to download in the GoToWebinar control panel. If you're able to ask a question, you should see that panel. You should have a way to get to the section that says handouts, 2 of 5. One of those handouts is the copy of the PowerPoint slides. If for some reason you don't get it, you can send Callie an email and she'll send it to you. So with that, I'm going to go ahead and close out. We thank everybody for attending. We look forward to talking to you again in the near future. For those that are clients of US Drug Test Centers, we thank you so much for being a client and putting your trust in US Drug Test Centers to help you with your DOT drug and alcohol testing compliance. Have a great rest of your day.